Welcome to another episode of Nooner Conversations. I'm your host, Scott Lay. My guest today is a return guest and a friend of the Nooner, Chris Micheli. He's a lawyer and lobbyist here in Sacramento, as well as he teaches legislative process at McGeorge School of Law. So we'll get a little bit into legislative process and his latest academic works toward the end of the podcast, which runs about 50 minutes. But before that, we're going to talk about the first 7 months of the legislative year and what we saw as a legislature, was still working under pandemic precautions mostly, with most legislative staff working at home. And toward the end, we saw several legislative staff members test positive for the virus, including about half of whom were fully vaccinated. Now, we don't know how many were symptomatic or not, but it's still something to think about before the legislature returns for the final month of its legislative session, which begins on August 16th. So we talked about what to expect in the last month of the legislative session, or legislative year, I should say, first year or 2-year session, and how the recall effort, which will affect that last month of the session. As you know, the recall election is on September 14th. Of course, people will start voting 29 days before that, and voting by mail, because every voter is going to be getting a mail-in ballot. So how will that affect the dynamics of the legislation? And legislators are going to send bills to the governor's office, and they don't know if it'll be Governor Newsom or somebody else who will be acting on that legislation. So it's a very interesting dynamic. Finally, we talk about his 2 latest casebooks. These are legal and undergraduate casebooks in both direct democracy in California, as well as the legislative process in California. So very, very relevant this year and most years in California. So it was a great conversation. I hope you enjoyed as well. Hey, Chris, nice to see you again.
Good to see you, Scott.
We've talked a few times over this very weird, 18 months it's been during the pandemic, which has disrupted the legislative process. And you've been an insider in it because you literally were going inside the building, even when many people were staying away. You were always well masked, but you'd pop up in an empty hearing room or in the chamber above the Assembly or Senate floors to speak on a bill, because they were using the Assembly and Senate floors for committee hearings, because they still can really use a few spaces on each side of the House or each side of the Capitol. So what are your takeaways for those first 7 months?
In the 2020 session?
In 2021.
The main takeaways were, I think the legislature, last year the legislature really tried its best to deal with the big unknown, which is how to operate during the pandemic. As you'll recall, about 75%, about 3 out of every 4 bills were dropped by the wayside, because obviously at the end of February of 2020, when it was the bill introduction deadline, it seemed like a perfectly normal year. And by March 16th, they had passed the emergency budget authority to the governor and got out of town for what was supposed to be 2 or 3 weeks. And obviously it was more than twice that. And then they had to figure out how to operate. And I, honestly congratulate the members and the staff, particularly in the 2 leadership offices, Pro Tem Atkins and Speaker Rendon, for what they put together, especially when it comes to public participation and all of the remote testimony. I mean, despite all the problems with, like telephone testimony and the agony of having to sit there and listen in the committee hearing with the members when people are saying, "Can you hear me?" And all that stuff. Anyway, sounds like those old, phone commercials,
and
right?
The occasional F-bomb, if you will.
Yes, there were definitely a few hearings the last 15, 16 months where I've been sitting in a hearing and somebody decides, oh, they don't know who I am and I'm not in the room, so maybe there's nothing they can do about it. And yes, they drop the S word, the F word, or whatever else. But yeah, and then we kept thinking that, oh, maybe by the end of the 2020 session, everything would be back to normal. And obviously it wasn't. And so they, had contemplated maybe some bill limits, obviously swore in a handful of new members last December, and off they were to the races for the 2021 session. The way I sort of described it is they basically had a normal session in terms of bill loads and all, but did it under pandemic conditions. Now, to be fair, when we hit the House of Origin deadline at the end of May, the two leaders did impose the 12 bill cap, which affected a handful of assembly members, but quite a few senators. So there were quite a few of them who had to move bills to the inactive files on their respective floors. And I think that's the way it's going through September 10th. They're scheduled adjournment at this stage, but obviously there are some unknowns. The legislature's out on recess. LA County certainly is masked up again, but that's always been the procedure in the Capitol. By the way, Scott, it leads me to something to mention. When the handful of assembly positive COVID diagnoses memos came out a few weeks ago, and then the senior staff for, Erica Contreras, the Secretary of the Senate, and Deborah Gravert, the Chief Administrative Officer for the Assembly, wrote to their respective members and staffers in the Assembly and Senate and said, hey, we're going back to the old rule. The press reported there's a mask mandate again in the Capitol. Well, it never was allowed to be maskless in the public areas, in committee hearing rooms, in the gallery, or anywhere else. What the issue was is that legislators and staff in their own offices, when no one else was around, could go mask free. And so all they said was, hey, when you're back in your office, you got to keep the mask on at all times. But the press didn't understand that important distinction, because otherwise they've never relaxed the mask mandate, certainly not for the public everywhere we go in the Capitol.
Right. And I didn't really understand what they meant about we're going back to the old rules, whether that meant the capacity limits of public, members of the public. I would say we've had, when we talk about members of the public, there's two sectors of the members of the public. There are those with official business and those that, the tourists. And, I heard from lobbyists that were in the Capitol and staffers that were happy to see tourists walking around again. And
I think the first few weeks, Scott, that the Capitol has been, open to the public, the number of members of the public has far outweighed the number of members of the public with business to do in the Capitol. So lobbyists and other people who have come for hearings or for meetings have been outnumbered, barely on the first floor, because you walk Capitol. These last few weeks saw lots of first floor, wandering around the old section, wandering around the annex to see the county displays and the governor's office and the Golden Bear. But then on floors 2 through 6, where legislative offices and hearing rooms are, it was completely barren for the most part.
That's interesting. Speaking of the annex, there hasn't been much news lately about whether the annex move out is going to happen after the end of session this year. for the reconstruction of it. The building will be, the new building, the swing space they call it, will be ready. But have you heard anything whether the pandemic has delayed that? Because I know some staff did go in to pack up their stuff because they were told to, but it's kind of crickets, if you will, on that front, not hearing much.
It's my understanding that staff did get a notice last week to be prepared to move at the end of September or early October. The swing space is on schedule. It was not delayed. They were doing work the entire time during the pandemic, sort of like across the street from my office at the convention center and community center here. That never stopped a single day, and neither has the swing space. And legislative staff were told that the recess would be a good time to pack up some of the personal items and go through their files and other materials, because they will have limited space when they're over in that new office building for a couple of years, and to take some things home, I think, as well, because again, they won't have a lot of space for things. And so
I'm glad to hear about the community center, because I have tickets for Hamilton in September there.
Well, it looks like it'll be ready to go from what I can tell. Definitely.
Yeah.
Yeah.
That's interesting. Now, so they come back on August 16th for, shortly less than 1 month.
4 full weeks.
Yeah. Final sprint of the legislative session. And what are you anticipating for that? And in particular, we've got the recall effort going on, and that election is September 14th. And people think things have heated up. They have not heated up at all. I mean, we've got one candidate carrying a ball of trash around the state. Assemblymember Kiley is talking about, school vouchers. But, the ad wars haven't really started. The no on recall ads have started a little bit, but, there's going to be some big money. Although I think that on the Republican side, the big donors are wondering where to put money. Are they going to get behind one candidate or another? We just don't know that. But nobody can go in the Capitol building and with earplugs on and not pay attention to what's happening politically outside. And we experience that in normal election years, although normal election years, they're gone in the end of August and the election's not until November. Whereas they're around until 4 days before the election.
Yeah.
So how does that affect the final month, the sprint to the end of session? Or end of the
legislature. Yeah, I think that the legislature is going to push on with the hundreds of bills that it has. There are several hundred bills, of course, that are pending on the 2 appropriation suspense files, and they'll be adding that first week back, August 16th, Senate appropriations and August 18th, Assembly appropriations, in preparation for the votes on the suspense files. I think the following week, Thursday, September 26th, is when they're going to do the suspense files. And then those last 2 weeks of the session, they'll be dealing with the hundreds of bills that come off of suspense. And by the way, there's already been 114 bills as of yesterday that the governor has signed, and probably another 24 on his desk. So I think we're going to see more of a normal year this year in terms of bills getting down to the governor. Last year it averages between about 1,200 bills get down to the governor's desk. Last year, we saw about 600 odd bills that got down, obviously substantially impacted by the pandemic. This year, I think we're going to get back to, 1,000 bills that'll get down to the governor's desk. We're obviously seeing the impact of the recall politics in terms of legislation and certainly the budget. And, the governor's doing what the governor should do in this position, whether running for re-election or running in the recall, touting the budget agreement, the spending accord, and where they're putting the money. Earlier this week, yesterday, he did LA at the Hollywood Studios with the Portantino bill on substantially increasing the tax credits available for the TV and motion picture credit. He did a Central Valley press conference on the big broadband deployment budget trailer bill. Yesterday, he also did the bill on organized retail theft, which is a big topic, especially like in the Bay Area where people are, walking out of Walmarts and stuff with products. So clearly, it has an impact, but I think the legislature would naturally be doing most of the bills it's doing, regardless of whether there were the pending recall on September 14th, from my perspective.
Yeah, that organized retail theft is interesting because, well, you're a lawyer and you know that basically the large retailers, Walgreens, Walmart, et cetera, have basically told staff, don't intervene, because if staff get injured on the job, it's a much bigger liability than the cost of goods being stolen.
Yeah, sure.
I mean, there's a lot of questions as to whether, the CHP is really going to be able to amp up its enforcement, pursuant to that trailer. But it'll be interesting to see. Now, I did hear from several people that, the pressure to have the earliest practical recall election date was partially so that the bill signing period would largely be after the election. So the governor wouldn't be put in the position of making tough decisions, either paddling on the left to appease his base and funders, or paddling on, more the moderate to right to minimize, the loss of no party preference voters, more conservative and conservative Democrats. I don't know, and so it was. I mean, the county elections officer said not before September 7th for an election. Secretary of State Weber went with September 14th, which, given the timeline and with the lawsuits we saw yesterday in Sacramento Superior, you think about printing 20 million ballots, and had it been September 7th, even that was a very big turnaround time. I mean, counties were just told yesterday, here is your ballot order for candidates, because it changes in every county sequentially through a randomized alphabet. And the counties now have to procure printing for all those ballots. Now they have people that were expecting.
Although the state has pre-funded that to the tune of about 200.
But legislators, when they approve bills, there is a chance that, that the governor's office switches parties. And from the lineup we're seeing, it's largely conservative, with Kevin Faulconer, former mayor of San Diego, although he can't have that on the ballot. He's the most moderate. But if you believe a poll that I have doubts about that came out yesterday, that was largely name recognition at a very early point, Larry Elder is in the lead, although it's a very small percent. I mean, that would be a huge swing. I mean, it's one that we haven't seen. I haven't seen in my lifetime. You might say Ronald Reagan, but I think he's even more conservative than Ronald Reagan. But he has very little positions. But I don't know. I mean, I guess legislators just roll the dice, and they have to run for election next year. We know that although the district lines will be redrawn by the redistricting commission as late as for a June election, most legislators will be in safe districts, and Democrats likely will continue with 2/3 supermajority in both houses. And so I'm guessing they're just going to send, their base, the bills that their base wants to the governor.
Yeah.
And just have you on to talk about two new books. They're Casebooks that go beyond the kind of writing that you've done before, both for your students at McGeorge School of Law, taking legislative process, and for the broader Capitol community and those interested. So let's start, and I'll put links to the books in the show notes for everybody. But let's start about talking about direct democracy, which plays off one of the subjects we were just talking about, which is the recall, which was one of three reform era measures pushed by constitutional amendments pushed by Governor Hiram Johnson, a progressive Republican. And so this is you have a book, Direct Democracy in California, which most people would say is far different than what was envisioned by Hiram Johnson, which was to challenge the special interests. And most people say, well, you can't qualify, but with the size of California now, you can't qualify an initiative unless you are a special interest. So talk about your book, the gist of it, and other perspectives you have about direct democracy.
Yeah, well, thanks, Scott. My initial effort, and obviously this is previewing the second one that was just recently published on the legislature. But I thought it's hard to talk about the legislature and the legislative process without looking at lawmaking through direct democracy. And when I started delving into that portion of the casebook, I realized, oh my gosh, there's more than enough material for one on direct democracy. And California is one of about 24 states that has different forms of direct democracy. Now, we know that not all those states have all three forms. For example, New York doesn't have a recall process, right? That's why the governor, with some of his controversies that he's had this year and before, is not subject to a recall like our governor is with the scandals there. But as you can imagine, the recall is actually very little used in the state of California. It might be hard to believe because this year, 2021, and then of course in 2003, 18 years ago, we had the first gubernatorial recall in the state's history, and now 18 years later, the second. We've had a handful of legislators, most unsuccessful, some successful, but it's more used at local government level. The referendum, the second form of direct democracy that California has, of course, is basically a check on the legislature. It only comes into play when the legislature enacts a statute and the government court lets it come off. Form a very quick turnaround. In fact, for the electorate to decide, you know what, we want to, in essence, override it or veto it, take it away. Now, that historically has not been used very often either, but in recent years we've seen it. And obviously the electorate at the last statewide election overturned the zero bail measure that the Governor Brown worked on. Chief Justice Tani Kantil Sakaui, Rob Bonta, our now AG, the Senate Majority Leader Bob Hertzberg, and others. Speaker Rendon did. And we have another one. The ban on flavored tobacco has made it, the referendum that is, has made it to the November 2022 ballot. So we're seeing it be more actively used. And then, of course, the third and most prevalent form of direct democracy is the initiative. And God, Scott, you could do multiple case books just on the initiative process because we have so many appellate court decisions and a great deal of guidance, everything from the ballot title and summary to the single subject rule and everything in between. There's so much law, case law, and statutory and constitutional provisions related to the initiative. And of course, that's the lawmaking. Remember, the people can both propose and adopt constitutional amendments as well as statutory changes or additions. So there's a lot out there. And again, California is clearly the leader when it comes to the use of direct democracy amongst the 24 states that have it. And we've done so much lawmaking. You know, one of the criticisms on the fiscal or budget side is how much ballot box budgeting the legislature has been locked into by the electorate, whether it's minimum spending or what you can spend, or of course, critics of Prop 13 and other ballot measures on the tax side have been critical. But it's very prevalent here, and so there's a lot of law for folks to understand. And I tried to put both casebooks together for not just law school students, but also college, state government students to utilize as well.
Yeah, well, it's interesting because, again, the referendum, was put in for citizens uprising. It was the dominant railroads was the issue with the legislature in the Hiram Johnson era, and it was the citizens, and sponsored by the governor, were like, we need to stop the special interest railroads from dominating California state policy.
Yes. Sure.
But the referendum, the referenda that we've seen in the last, or I'd say, and we saw in 2020, and we're going to see in 2022, those are purely industry driven. And people think with the bail bonds one, that it's like these little bail bond shops that are across courthouses around the state that were the big sponsors behind it. They were the face of it. It was really the big insurance companies that sponsor bail bonds. The bail bonds shops are basically resellers of insurance. And obviously for the flavored tobacco, we know who's behind the flavored tobacco ban. To reverse that, we know who qualified the referendum. And
Sure.
that one is going to be, I think, harder. Bail bonds, that was an easy message to craft against, to deny the legislature's law. I think flavored tobacco, based on polling I've seen, it's going to be harder to craft a message about why, menthol cigarettes are still good. But
Makes sense. Yeah.
We'll see. Now, I don't know if you have an opinion on this, but I found it interesting that last year, first we had an extension of the deadline for initiatives, which is the deadlines for initiatives are provided for in statute. And then the deadlines for recall are in the Constitution. And the same Judge Argeles here in Sacramento Superior, held that, extended the deadlines for both in separate proceedings. And some people, including me, believe that that was a little bit of an extrajudicial act to extend the deadline for a recall, because that deadline's in the Constitution, approved by the voters, as opposed to in statute approved by the legislature, where generally judges can,
less deference is given there.
Yeah. You kind of had the three steps would be regulatory, statutory, and constitutional, with, going from least or most deference to least deference at the constitutional level. Most people believe, I believe, that the recall had no chance of qualifying had that extension not been provided, because the big money didn't come in until after that. So it's interesting. Now, so moving on to your book, California Legislature and its Legislative Process, how much, and tying it to the other book, how much does the direct democracy options for industry and voters play into the legislative proceedings? Do the legislators have on their mind, what might happen? We knew, and I know you worked on the issue some, but we knew that Uber, Lyft, and others were going to challenge provisions of AB 5. That was openly talked about, and there were options to remove them from the bill. That didn't happen. But we don't need to talk about that bill in particular, but how much do legislators actually think about what might happen? I know Jerry Hill Senator Jerry Hill said, I don't care if they take my bill to the ballot. I'm going to fight like hell to get it implemented. And he authored the flavored tobacco bill. And sure enough, they had warned, they said, we're going to take it to the ballot. But I think he is kind of takes it as a badge of honor, you know, and certainly if the voters uphold the law, which is always confusing because it's yes,
counterintuitive.
It's totally counterintuitive. But so how much does the direct democracy intervene with the legislative process, if any or at all?
Well, it's, as you've noted, it comes up in not only conversations, but committee hearings and on the floor. I mean, for example, last year when Assemblymember Gonzalez and Senator Allen were presenting their similar bills in the Assembly and the Senate on plastic recycling, they both said, and I think Assemblymember Gonzalez very explicitly said, look, we can either deal with this here or they're going to deal with it on the ballot by the people. And both proponents and opponents, as well as the legislature, would be better off if it's done as part of the legislative process. You may recall a few years ago that a ballot measure on privacy had qualified for the ballot, and Assemblyman Ed Chow, the ultimate privacy committee chair until just recently, Senator Hertzberg, as the Senate Majority Leader, came together with the proponent of that ballot measure and ultimately crafted a statute that was passed and signed by the governor on the same day that it was the deadline to remove that proposal, which ultimately became the CCPA, from the ballot. So in that case, it was used explicitly as the proverbial hammer over the head of the legislature to do a legislative deal.
Well, and the advantage, I mean, for people that don't really know this part of it, when a statute is passed by the legislature, it can be easily amended. Whereas if a statute is passed by initiative process, it can really be only amended as provided for by the initiative. So people will put in initiative language, and I've sponsored an initiative and wrote language, things can be approved by the legislature in furtherance of this act.
Yes.
But that's locked in. It's in the same book, the same statutory book as laws passed by the legislature, but initiatives usually can't be amended too much by the legislature. And I know on the plastics one, which just qualified this week, formally qualified. I mean, we knew signatures were there, but it's formally eligible for the next November's ballot. Now, a change in law, I believe it was a Steinberg bill,
That's correct.
now allows the sponsors can withdraw it all the way up to a deadline mid next year for the November 22.
That's basically the third week in June. So yeah.
Right. So because that bill goes stronger, it's sponsored by environmentalists. They didn't have to do any compromising. It goes stronger than the Gonzalez and Allen bills in last year. I don't know.
Exactly.
The years kind of all go together.
Well, they did it over 2 years in both 2019 and 2020. So yes.
Yeah. Oh yeah, it was 2019 is when I'm thinking about SB. I don't know, 1088 and SB 27, something like that.
No, yeah, they were different. AB 1080 and SB. Yes, I don't recall offhand, but
I just remembered that was.
Most of those go out the door after session ends because I have to think about this year's bills.
Well, I remember that that session and sitting up in the gallery of 4202 because the Senate floor was evacuated for hazardous material, biohazards.
Right. It was SB 54, by the way. Sorry.
Oh, there you go.
1080 and 54. Yeah, sponsored by Californians Against Waste, as I recall. So.
Yeah, SB 27 was the tax return disclosure bill for
Oh, yes.
presidential candidates and governors, which we
Yes,
just
in
heard
the
a lot about
primary, by
yesterday.
the way,
Yes.
which I saw that the Superior Court judge used this week, that it doesn't apply to the recall, it applies to primaries. But
That's exactly how I read it, and I wrote about that before the hearing yesterday. I think all of the hearings yesterday on the ballot were correct. Some going in favor of Secretary of State Weber's office, and some going against her. But
well, certainly the ballot
46
designations, right? Like retired mayor and yes.
And the name, you can't say I'm Kevin. Was it? I'm Kevin. No, Kevin. What is
Meet Kevin? Meet Kevin.
Me, Kevin, which is his website address.
Right. Right.
Pafroff. It was a hilarious hearing. But okay, a little bit more on your legislative process book, your case book.
Sure.
What you experienced in doing the research for it, your approach, and the takeaways.
Yeah, I have to. I hesitate because the hardest part is sort of getting your arms around what to include and how to cover things. In my mind, at least, and perhaps other, full-time law faculty view casebooks differently. I'm not a full-time faculty member, nor have I ever written one. I read many of them during law school, but that was the extent of it. And God, that was over 20 years ago anyways. In my mind, I tried to think about, okay, I want to explain aspects of the legislature and the process, because they are two distinct things. And what do I mean by that? On the legislature, you have, everything from how they're elected, the powers and authority and duties of the legislature and the legislative branch of government, and their ethics and lots of different things. And then you have the process stuff, the interactions with the governor's office and how the bills become law and all of that. So the first thing I was trying to figure out is, okay, of all the constitutional and statutory, provisions of law that are applicable to both the legislature and the legislative process, what are the key points I want to communicate? Because one thing for sure is you can't cover everything, because it would be well over 1,000 pages, if not many more. And it ended up being 772, which is plenty long. But believe me, there was tons that I didn't cover or struck. So you got to figure out, what do you want to include? Then once you sort of figure that out, how do you present it? In other words, what do you start with? What's in the middle? What's in the end? And then you also have to look at for purposes of a casebook, of course, and that's different from a book about the legislature or about the process. You can just explain the laws and what's going on. With a casebook, you obviously need cases. So as you can probably figure out, there are provisions of law both applicable to the legislature itself as well as to the legislative process that, guess what, have no reported appellate court decisions. So it may be an important point. So you give some description to it, but you don't spend a lot of time on it because there are no reported cases. Then, as you can probably also imagine, Scott, there may be provisions of law that have one reported case. Well, that's pretty easy, and hopefully it's a decent case. But then you have other provisions, again, I'll cite single subject, as just like in initiative, there's also a single subject rule for legislation. Well, there are hundreds of cases, and certainly many of them are repetitious, but you've got to cover it with more than one case because there are different aspects to it. And so, just like there's a ton of cases about the power of the legislature, there are hundreds of cases out there. And so you got to sort of pick the main ones, but you also have to spend time reading through them to see, are these good cases? Well, what's a good case? Well, in my mind, for a casebook purpose, it's one that's well written, right? With a good analysis that helps explain the law. I mean, there are some cases where, the Court of Appeal justices or the Supreme Court justices may just go right to the heart of it and, quickly dispense with the issue. There are others where they really explain the law, or they explain the history, or they go over, decades worth of cases and decide why they apply or don't apply in this particular one. They may, describe new law in an appellate court decision and all that. So you've also got to spend time. So even when you've identified cases and say, okay, here are like 5 great cases for this government code provision, well, then you read through them and you think, God, I'm only going to include one of them because it's well written and it explains the law and all of that. So I've been a little long-winded here, but I mean, those are sort of the things that go into it. Again, in summary, it's like, what do you want to include? How are you going to present the information? And then you're filling in the cases where they go to help explain the law. So it takes a lot of organization to get there.
Yeah, and it ties back to an earlier conversation about, yesterday's hearings in Sacramento Superior, and most elections related cases are basically statutory interpretation and regulatory interpretation. And
absolutely,
it's usually plain reading. Maybe you get to legislative intent, but there was no discussion about cases because they really aren't. I mean, either an appellate court either will accept it for review or deny it completely, or immediately remand it back to the trial court and say, work on this some more. Mm-hmm. And so you don't have anything written, on those types of cases.
Yeah. Well, and there's a lot of things that are obviously decided at the trial court level that never go up on appeal, that get resolved. And then you also find some cases are, decided on a very narrow basis. And so it's hard to say, well, this is so precedent setting or very helpful to this area of the law because it was decided on such a narrow issue. So again, that's a lot of, what you're going through to present this. So, anyone who's familiar with these topics could obviously come in and say, well, I would have presented it this way, or I would have included, this case or that case. I mean, ultimately there's so much out there. The hardest part is whittling it down to a manageable level, because whether you're a college student or law school student, you have a semester long course. So you can't, read several thousand pages and, no instructor or professor is going to do that. And if you're reading it because you're interested in the area, you're not taking a course on it, but you're a lobbyist or someone who works at the Capitol, you're also not going to, spend weeks digesting it either. So again, you've got to, limit what you're putting in there. And by the way, like traditional law school case books, I do have a section at the end of each case and some of the descriptive areas, what I've called notes and questions. So where I add some additional thought or insight, and then certainly raise some questions. And naturally, that's more for the college or law school student to pay attention to, trying to prompt some additional thought, or, hey, what about if the fact pattern with this were this, would you still decide this the court did here? Or maybe I raised some issues, in terms of the court's interpretation. I mean, as you appreciate, in our minds, judges don't always get it right in our mind. I always remember my first torts professor. He was a retired trial court judge. And our torts class, he said, just because we wear a black robe doesn't mean we get everything right. I remember that so distinctly from Judge Adams, and I would concur at this that especially when it comes to things like legislative intent and statutory interpretation, I find myself not always agreeing with this state Supreme Court or the U.S. Supreme Court, but ultimately they are the final arbitrators, and what they say stands. But it doesn't mean that we can't respectfully disagree. And I think that's part of the learning experience in college or law school, giving some thought. Hey, do you think they decided this wrong?
In many cases, it relies on the facts presented and the attorneys that are arguing the cases. Because, a judge can only consider what has been proffered to them. They can't just go out and research the facts on their own and introduce them on their own, or they shouldn't. It's been done. But that's, that was one of the interesting things back on the Meet Kevin case yesterday. He was saying, can I change my name for next November's or next year's election? Because I've got this groundswell of support. If I legally change my name, which takes 30 days, will that be upheld? And the judge wisely said, that is not before me right now. And if it comes before me, I'll look at the facts at the time. And of course, if he legally changes his name, it would be allowed,
I recall, in fact, that there was a former state senator, Omar Raines, who several decades ago apparently had petitioned a superior court judge to allow him to change his name to Senator Omar Raines. After he was out of office, he did a name change filing, and the court said, no, you can't change your first name to Senator.
Good for the court. Well, an interesting legislative process issue that's come up over the last couple of weeks is Texas, the quorum requirement. Now, Texas has a 60 member require. They have different numbers in their legislature. I know it's 60% members have to be present in order to vote for votes to be handled. And of course, the governor wants to advance voting legislation, as well as some other issues, I believe, in special session. And so Democrats took off to Washington, D.C. to allegedly lobby for voting rights legislation. They brought with them
federal
COVID,
level.
and they brought with them a COVID outbreak in the U.S. Capitol. I think 7 members of the state legislature ended up with testing positive, as did a staff member for House Speaker Nancy Pelosi of San Francisco. But so California has a simple majority quorum requirement. And the last time we saw this actually be affected was in the 1994 speakership fight, where because of a special election of Dick Mountjoy, who won a Senate seat in a special, but tried to stay in so he could win it in a special and run for assembly at the same time. He won both, tried to stay in the assembly, and the assembly kicked him out. But then
he didn't go take his Senate seat.
Yeah, go take your Senate seat. But then Republicans wanted to block, after one Republican defected to Willie Brown's side, Republicans went across the street to the Hyatt. And so there wasn't a simple quorum. That stalemate happened for a couple of days. I mean, legally, the sergeants at arms can be ordered to go across the street and arrest them.
Yes.
Not a real popular thing to do if you're
leadership.
legislative
Probably not.
But I mean, did you look at that issue at all? I mean, quorum requirements. I mean, I've never seen a matrix of what legislatures, I guess National Council of State Legislatures probably have it.
Yeah, NCSL might. No, I mean, as you noted, in California, it's a simple majority Assembly and Senate, and obviously today, for example, there's more than a supermajority in both houses, so that's not a threat at all. if the minority party walked out of the building, they're not necessary. Now, as you also know, the custom and practice in the two houses, for example, in committees, is that you either wait for a Republican member, or in some instances, chairs wait for the Republican vice chair to show up before they even start as a so-called subcommittee. Doesn't happen 100% across the board in both houses and every single committee, but in general, I would call that a custom and practice of our house. So I think despite the partisanship that even exists in the California legislature, I think when it comes to, process type things, that the legislature is respectful of majority rule, but also minority party participation in things.
And even during those tough times in 1994, that was my first year up here. I was undergraduate at Davis at the time, but I started doing more work around the Capitol. I had been lobbying as a student advocate before that. But there's been a tradition of comity in the Capitol, not comedy, but comity, of respect for members.
Yes.
It's very rare. I mean, there have been fistfights, but that was decades and decades ago. Well, I think there was, did Dick Floyd? I think there was one a couple of decades ago.
Well, there was an almost about a half a dozen years ago, but it didn't come to fisticuffs, but it got close.
Yeah. Well, it's, I love the legislature, and I love the work you do. For those that don't know, Chris is well known for putting out lots of data on bills, the passage rates, that sort of thing that he tracks. And so while his lobbying practice is, I basically considered, a business lobbying practice. I know, yeah. I mean, members of the goody caucus of lobbyists, that represent nonprofits and that sort of thing, think very highly of you, and your work is very much appreciated in the Capitol community. So I want to thank you for joining another Nooner Conversation. Do you have any final comments?
No, I always, as you know well, Scott, from years talking formally and informally, I love the legislature. I love the legislative process, and enjoy the job that I have in this world of lobbying, and enjoy the work that I do with my colleagues in particular. I think there are so many wonderful people in elected office, appointed office, their staff, and certainly my colleagues in the lobbying profession. And I've been very fortunate to have some wonderful mentors for myself over the years, and I'm trying to pass that information along to others and keep people apprised of what's going on. And I think over the last year and a half in COVID has really demonstrated the need to, keep the public apprised of what's going on and help with as much transparency as possible to ensure that the public knows what's going on and has the ability to participate in the lawmaking process. And again, I would give accolades to legislative staff, particularly in the leadership, who even after the June 15th reopening have committed to, participation by telephone, for example, and continuing to have legislators and staff do Zoom meetings with lobbyists and their constituents to allow that continued public participation. So, I'm trying to do my small part in this.
Well, I think you and I have talked about it before. You have experience in Washington's capital, Washington, D.C.'s capital, which is very different, where lobbyists basically work with a very small subset of staff and only see their own subject matter lobbyists, whereas in Sacramento, you interact with everybody. And when you have an appropriations committee hearing, you see people from all, lobbying perspectives and political perspectives. And that's what I love about it. It is a true community, and you foster that spirit. And I thank you very much. And I thank you for participating in another Nooner Conversation. Welcome to another episode of Nooner Conversations. I'm your host, Scott Lay. My guest today is a return guest and a friend of the Nooner, Chris Micheli. He's a lawyer and lobbyist here in Sacramento, as well as he teaches legislative process at McGeorge School of Law. So we'll get a little bit into legislative process and his latest academic works toward the end of the podcast, which runs about 50 minutes. But before that, we're going to talk about the first 7 months of the legislative year and what we saw as a legislature, was still working under pandemic precautions mostly, with most legislative staff working at home. And toward the end, we saw several legislative staff members test positive for the virus, including about half of whom were fully vaccinated. Now we don't know how many were symptomatic or not, but it's still something to think about before the legislature returns for the final month of its legislative session, which begins on August 16th. So we talked about what to expect in the last month of the legislative session, or legislative year, I should say, first year or 2 year session, and how the recall effort, which will affect that last month of the session. As you know, the recall election is on September 14th. Of course, people will start voting 29 days before that, and voting by mail, because every voter is going to be getting a mail-in ballot. So how will that affect the dynamics of the legislation? And legislators are going to send bills to the governor's office, and they don't know if it'll be Governor Newsom or somebody else who will be acting on that legislation. So it's a very interesting dynamic. Finally, we talk about his two latest casebooks. These are legal and undergraduate casebooks in both direct democracy in California, as well as the legislative process in California. So very, very relevant this year and most years in California. So it was a great conversation. I hope you enjoyed as well. Welcome to another episode of Nooner Conversations. I'm your host, Scott Lay. My guest today is a return guest and a friend of the Nooner, Chris Micheli. He's a lawyer and lobbyist here in Sacramento, as well as he teaches legislative process at McGeorge School of Law. So we'll get a little bit into legislative process and his latest academic works toward the end of the podcast, which runs about 50 minutes. But before that, we're going to talk about the first 7 months of the legislative year and what we saw as a legislature, was still working under pandemic precautions mostly, with most legislative staff working at home. And toward the end, we saw several legislative staff members test positive for the virus, including about half of whom were fully vaccinated. Now we don't know how many were symptomatic or not, but it's still something to think about before the legislature returns for the final month of its legislative session, which begins on August 16th. So we talked about what to expect in the last month of the legislative session, or legislative year, I should say, first year or 2 year session, and how the recall effort, which will affect that last month of the session. As you know, the recall election is on September 14th. Of course, people will start voting 29 days before that, and voting by mail, because every voter is going to be getting a mail-in ballot. So how will that affect the dynamics of the legislation? And legislators are going to send bills to the governor's office, and they don't know if it'll be Governor Newsom or somebody else who will be acting on that legislation. So it's a very interesting dynamic. Finally, we talk about his two latest casebooks. These are legal and undergraduate casebooks in both direct democracy in California, as well as the legislative process in California. So very, very relevant this year and most years in California. So it was a great conversation. I hope you enjoyed as well.